Attorneys. Have you ever had a case where you violated the attorney-client privilege? Story 1. I, 22 years old female, am about to graduate college and landed my first job at a law firm. I have wanted to be a lawyer for as long as I can remember. I work as a waitress in a restaurant with many locations, and upon beginning work for the law firm, I learned this restaurant was a client of the firm. I dumbly made mention of this to the general manager of the store when I first started at the firm. She asked me if I had seen anything about our store in Chicago, and I said no. The firm I was at was representing the restaurant in a different state. I understand this was a huge mistake, and this was a breach of confidentiality. I have certainly learned my lesson. About 2 months after this conversation with my manager, where I am 2 months into my job at the law firm, I start having issues with the manager at the restaurant and decide to talk to Human Resources, HR. Very normally, I made no crazy accusations or statements. I just said I was concerned about the way something was handled by management. 30 minutes after I get off the phone with the restaurant's HR team, the law firm calls me to tell me I am terminated because I broke confidentiality and the client is demanding action. The restaurant manager told a coworker that when HR called her to ask about the situation, she said, "We need to be careful with her because she works at a law firm." Who knows what was really said, but I was terminated from the law firm because of this. I have been applying to jobs and had many interviews and ultimately no luck, even on interviews that went super well. I have not been using the law firm as a reference or saying I worked there. I am scared I will never be able to work in law. Is this on my record or something? This has always been my dream. Story 2. I have finally found out one of the reasons that I was having an increased problem with leaving my abuser and how it seemed he was being informed about my gathering of information on what to do and my rights. That is, can't throw me out in the street naked in the middle of December, January, February, and literally every month this was happening, and how to stay safe. After having a hunch, based on many comment he would say that made me think it was odd, I did some research and found out that a worker at one of the firms I contacted for legal advice is the brother of one of his ex-girlfriends. A worker at another firm was an ex-girlfriend, and potentially someone he was sleeping with and maybe is with currently. Sadly, this isn't at all a concern, but just for mapping the relationship circumstances related to the post. This resulted in increased physical violence against me, including assault and sexual assault, and made me at risk and have multiple more attempts prolonging my situation. Considering I have the emails of me reaching out to the companies and screenshots of LinkedIn that shows the staff members, I had to reactivate to do this. I'm wondering if I can report this to any sort of third party. My life was put in danger due to them disclosing what I thought was confidential information even though it wasn't in detail. I was never told there was a conflict of interest, and I am aware to not disclose details until a lawyer is retained. I don't know how they had access to my inquiry if I wasn't dealing directly with them at the company. Is this something I'd contact the Law Society of Canada over and they would investigate? This video does not promote illegal activity. Stories are shared for commentary and education. Story 3. Hi, I'm in New Jersey. This is my situation. A family member who's involved in the fight over my father's estate is also a criminal defense lawyer. This person wanted a copy of my counterclaim before it was submitted to the courts. Their husband, also a criminal defense attorney with a claim in my father's estate, admitted that she called someone she knows at the firm I've hired to represent me. Her contact gave her a copy of my counterclaim without informing my attorney. I do know the name of her contact at the law firm because she had previously told me she knew this attorney. Is what she did legal? I have not informed my attorney yet that I know this family member has done this. I'm just wondering if what she has done is legal, and if it isn't, advice on how to proceed is greatly appreciated. Story 4. My friend is selling his business and retiring. It's a very successful, long-standing business in his town. He hired an attorney that's been a long-time customer of his to handle the transaction. He found out through another customer that the attorney is allegedly telling various people that he's handling the sale. The asset purchase agreement has been signed, and the place is all but sold. He allegedly even told people the name of the buyer. It's my understanding the buyer isn't happy about this situation either. Now my friend's employees are all bent out of shape, worried they might not have a job with the new owner. That's not the case, but they are all in a panic and my friend is worried he might lose his staff before the sale goes through. I guess half of the staff is already talking about looking for another job. My friend is at this point denying the place is being sold. He wanted all of this to be kept quiet and private until the very end. It's the talk of the town and surrounding areas now, and he said he is being bombarded by customers on a daily basis asking questions. He's very upset about it, and I immediately said, "This sounds like a violation of attorney-client privilege." I said, "Fire the attorney and sue him." He said he's worried about doing that because the attorney is a well-connected, powerful guy, the first guess. He's worried he could give him problems. What are your thoughts? Story 5. I am new at all this, so go easy on me. I am involved in a situation where a former attorney has returned 5 years later, wanting some money for phone conversations that were stated to be free at the time. I ultimately never signed with this attorney or gave them a retainer, as there were too many red flags why he should not be the choice to help with the issue I was having. But there is now a much bigger question. The bombshell I found out today is that this former attorney forwarded confidential emails I had with him 5 years ago to my new attorney. This was his attempt to try and show he offered some legal service 5 years ago. But the million-dollar question is, did this former attorney just break attorney/client privilege by sending private legal emails I had with him to my new attorney with me having any knowledge he was going to do this? If this really is the breaking of attorney/client privilege, that would be huge. Thank for your help. Story 6. We have an attorney that rents an office out of our company's building. He is not affiliated with our company at all. He came to me, Information Technology IT, and asked if I could help him with an attachment. Turns out, it was a winmail.dat file. He does not use Outlook, and sometimes, if you send from Outlook to a non-Outlook person, it jams all the attachments in there. Anyways, I was not thinking, and I uploaded the .dat file to a third-party website that can extract the files within. I did not realize that the files were attorney-client privilege before I did that, now reading the website's privacy statement. They delete the files every 2 hours, and he says he does not read them or share them, but he does not recommend anyone upload private stuff. I told the attorney that it was not being shared with anyone, because I did not believe it was at the time. In all reality, it's probably been deleted, and the information in the attachments were nothing special at all. I am freaking out a bit. Should I be worried? Story 7. Hello, I have a question, and looking for a little advice, or input if possible. Getting straight to the point, is it a violation of the rules of professional conduct for an attorney, paid or appointed, to meet/consult with their client, currently incarcerated, in a stairwell with other inmates, and a district attorney, DA, present? All, including a DA, are within earshot while the attorney is advising the client. As well as a possible rules of professional conduct violation, could this be considered a violation of the attorney-client privilege, if that is the correct terminology? Thank you in advance for any information, advice, input. I appreciate you taking the time to read this and provide feedback. Thanks again. Story 8. Almost 30 years of practice, but never a dull or ethically unchallenging moment. While representing a client in his private arbitration claim against a Fortune 500 corporation and their big law counsel, I accidentally disclosed an attorney-client communication during discovery. My state's ethical rules and interpreting Supreme Court decisions are crystal clear. If a privileged communication is received by adverse counsel, he or she must immediately stop their review, notify opposing counsel, and either return or destroy said communication. Despite the rules of professional conduct's RPC's directive, opposing counsel chooses not to disclose her receipt of the privileged communication until the arbitration, and based her cross-examination of my client on the erroneously disclosed communication. On my objection, she tried to argue that the crime-fraud exception to the privileged communication applied, and she had no duty to follow the RPCs and precedent. Upon further briefing, the arbitrator rightly struck the communication from the record, and my client prevailed on the merits for his claim. Adverse counsel has promised to vacate her client's adverse decision to the court. I have never filed an ethics complaint against another attorney, although plenty of opportunities have arisen over the years. I just find it too heavy-handed, and you may deprive someone the right to make a living or support their family out of their own poor or unknowing judgment. However, there is an affirmative requirement in the RPCs to report known ethical violations. As pissed off as I was at opposing counsel for pulling such a stunt, I do not think that she purposefully violated the RPC. I just think she was unaware, which is not an excuse, but is determinative in my mind. She is a young, assumedly non-equity partner, and looks bad enough to her client and managing partners. I don't want to pile on, but don't want to cite it for any RPC violations either. All thoughts and comments are welcome and will be considered. Story 9. I'm in the middle of 2 lawsuits right now. One is for workers' comp, and the other is for employment. My workers' comp attorney referred me to my current employment attorney. The problem I'm having with my employment attorney is he posts current lawsuits on his Instagram. He does black out his client's information and the defendants, but they're active lawsuits. They're cases he hasn't even won. But it frightens me that if he continues to post or discuss active lawsuits, that they'll either impact them or discredit me/his other clients. I didn't know about his Instagram prior to signing retainer. Dear, the legal advice subreddit, could this impact my case? Or am I overreacting? Too long. Didn't read. My attorney constantly talks about his clients' lawsuits, that are active not closed, on Instagram, and I fear it might jeopardize my own lawsuit. Seeking the opinion of other attorneys, if this may impact my lawsuit negatively. Story 10. May I tell two? 1. A mistake I didn't make almost by sheer luck. 1. Opposing counsel made. First, many years ago, a guy came to me wanting to sue his very big household name, Silicon Valley employer, for age discrimination. Brought in a buddy who also wanted to sue. I sat them down and was about to hear their stories, when a little voice in the back of my head told me I should be talking to them separately because their cases, though similar, were independent. Told them I needed to talk with them separately to preserve attorney-client privilege. Felt stupid doing it. They each rolled their eyes because of the paranoid young lawyer, but let me interview them separately. I took the original guy's case, but not his buddy's case. Fast forward a few months when this company is taking my guy's deposition. Huge conference room looking down on most of the other buildings in the San Francisco SF financial district. 3 lawyers on the other side, and me in my cheap suit on my side feeling outgunned. After the preliminaries, one of the first questions they ask is something like, "Has anyone else ever been present when you spoke with your attorney?" My guy looks at me like I'm a genius and says no. Now, I almost always ask that question. Second story, same type of issue. My guy and the other guy were former business partners. Other guy cheated my guy by siphoning off assets. We are both taking the deposition of a former employee bookkeeper who may know a lot of good stuff. Former employee is not represented and is trying to be neutral. Other side is buddying up like they're in the same camp. I ask a question. Lawyer for the other side objects. Noted, but I want an answer. He wants to go off the record for a few minutes. Takes the deponent into another room and chats for maybe 15 minutes. You see where I'm going with this? Comes back in. I ask if she's ready to resume, and she is. I remind her that I asked at the beginning if she had an attorney in this case, and she said she did not. She confirms. I say something like, "So, Mr. Opponent here is not you, lawyer?" She confirms. "Great," I say. "What did you just talk about in the other room?" I don't think I got anything really gold out of that, but the "oh crap" look on the other attorney's face is one I'll never forget. Remember who your client is. Story 11. I had a sexual assault case as a prosecutor where the defendant swore 6 ways to Sunday his DNA test would prove his innocence. The defense attorney, a very experienced but now disbarred due to a federal conviction for stealing a client's money they were trying to keep offshore, he's sitting in federal prison as we speak, attorney, whose advice was usually pretty spot on, even if he sometimes didn't even read the indictment until plea cutoff, told him they should oppose my motion to compel. He ultimately relented, and the DNA came back a la Maury Povich. The test confirmed he was the father of the baby born to the very young victim. The defense attorney was so pissed that when we went on the record, he congratulated his client on becoming a father and withdrew. This video does not promote illegal activity. Stories are shared for commentary and education. Story 12. I was in the middle of a trial when I found out my client's name, the one he was charged under, was not his real name. Fun times having to ask the judge to immediately withdraw, as I could not fulfill my duty to candor to the tribunal if I continued, while also holding my duty to attorney-client privilege. This video does not promote illegal activity. Stories are shared for commentary and education. Story 13. Yesterday I received a phone call after the hearing and a second continuance was granted because he decided to attain counsel. He is being investigated criminally on multiple counts of spousal, sexual assault, and domestic violence. I saw a law office calling me, so I let it go to voicemail, and when I listened to it and read it, it was not meant for me. It was meant for his client, which is my husband, who I'm also seeking an annulment from. I really don't know much about law, but I do know client-attorney privilege is sacred. Did he just break that with his client by leaving me information on my phone about the case for his side? What should I do? Any help is greatly appreciated. I do not want to help this jerk in any way, but I also want him to have a fair trial and hearing and don't feel right about this. This video does not promote illegal activity. Stories are shared for commentary and education. Story 14. In the judicial system in which I work, the confidentiality between client and lawyer is not very well defined in law. In practice, a lawyer will only get punished by the bar if they cause harm to their client, or by the courts if they pervert the course of justice. This being said, I daily break that principle. I tell my wife pretty much everything interesting that has happened in my day, the same way she does. She's a very senior police sergeant. Obviously, we don't talk to anyone else about the other's work. Police or judicial work are high-stress professions. Having a spouse one can trust to shut up about what one confides in them is a godsend and allows you to blow steam when it's useful. The sharing of secrets also strengthen our bond. I'm lucky that way, and even luckier to work in a judicial system that is not anal about principles. Edit. If the preceding sentence shocks you, I have tried to explain it in my response to another user. Story 15. Privilege applies to any meeting between a client and attorney in which a hypothetical person of sound, reasonable mind would believe the conversation is privileged. So if the jail has notified attorneys that certain rooms are safe to have privileged conversations, then they are safe. The jail can't pull a "just kidding, no take-backsies" later and use the recording in court, because both the client and attorney were on notice that the environment was safe for a legal meeting. Now, there have been scandals where law enforcement was in fact listening in secret. They weren't ever using the recordings in court, but they were trying to get the upper hand on a defense team by illegally recording them. This famously happened about 10 years back in New Orleans, Louisiana. The district attorney's office was secretly listening to confidential jail calls between attorneys and their clients in the hopes of getting ahead of their legal strategies. This was discovered and became a huge scandal. Just out of caution, I discourage clients from sharing too much information over the jail calls. The jail systems are required to label attorney calls as confidential and not record or listen to them, but accidents can happen even without a bad faith actor. There is also a more serious issue that I have to consider on bigger cases, which is that the federal authorities may decide they don't give a care about measly little state court defense attorneys like me and record something anyway. The federal authorities have been caught for decades engaging in all kinds of hyper-sophisticated extra-legal and illegal surveillance on American citizens, including in some rare instances on attorneys representing clients. The federal authorities also employ stingray devices, illegal warrantless surveillance of cell phone traffic in real time, and I have to imagine that their computer hacking tools are probably some of the best in existence. It's always in the back of my head that the federal authorities, if they so choose, could secretly record probably any and everything I'm doing on a case. It's not out of the realm of possibility that a computer virus exists on my protected government work computer that is secretly logging every keystroke for some super-duper Central Intelligence Agency Bureau of Alcohol, Tobacco, Firearms and Explosives Drug Enforcement Administration Federal Bureau of investigation into a client of mine. But as a practical matter, I rest easy at night with the awareness that I almost never have any cases that would get enough federal attention for them to take that risk, and the awareness that it's 99.9999% unusable in a courtroom. It's more for when they're interested in trying to bag terrorists or foreign drug cartel stuff. The biggest threat to attorney-client privilege is, unfortunately, my own clients. Many of them have poor legal understanding, poor emotional regulation, and poor impulse control. The roughest clients to work with are the ultra-controlling ones. The chronically abusive dudes that get in trouble for domestic after domestic after domestic. They often blow attorney-client privilege out of the misguided belief that they can use their attorney communications to intimidate witnesses or convince a court to drop the charges. In actuality, this only worsens their case and often subjects them to completely new charges. 2 hilarious examples. 1. I had one guy who was in trouble for 8 separate felony domestic assaults, 5 cases of which were all against a totally different woman, meaning he had relationships with 5 different women going at the same time, and he was assaulting, stalking, or controlling all 5 of them at the same time, somehow coming up with bail money each time he was arrested, and going out and doing it again. This guy was impossible to work with, literally impossible. Would explode on me into an uncontrollable screaming session within minutes of sitting down with him. So great was his need to control everyone and everything in his life that he would call his girlfriends on the jail phone system, which violated his protective orders and subjected him to additional felony charges every single time, and would then have that girlfriend call me. So let's recap. He's having a non-privileged, openly recorded phone call with his girlfriend, which is a felony caught on tape. Then, he's directing her to call me but without telling me that. This video does not promote illegal activity. Stories are shared for commentary and education. Story 16. I'm a lawyer in the United States. My practice is 100% criminal defense. It is the only law I have ever practiced. Many of my cases are serious felonies, including many sexual assaults and homicides. To begin, the premise of your question is wrong, or at least, the words are. Used in the legal context, guilty is a legal term of art. It does not mean factually responsible for the crime. It means your responsibility for the crime has been demonstrated beyond a reasonable doubt. This happens either by a defendant pleading guilty and admitting to an offense, or through a trial, usually to a jury. Prior to a finding of guilty, there is a, quote, presumption of innocence. This simply means that any person accused of any crime is assumed to be not guilty of that crime until the government provides proof beyond a reasonable doubt of their guilt. In a contested case, that obviously can't happen until trial. So legally, I've never started trial with a guilty person, because when the trial starts, none of my clients are guilty. They are all entitled to the presumption of innocence. Please note, there are some unusual defenses that occasionally require admitting to some level of guilt, but these are rare and unusual cases. I'm talking about the normal case here. In the United States, every person accused of a crime has a constitutional right to a trial. More importantly, that is an individual right that only the accused can assert, meaning the accused gets to choose whether or not to have a trial. Not the lawyer, not the prosecutor, not the judge, not even the jury. This constitutional guarantee isn't simply for the innocent. That wouldn't make sense, because 1, how would you know who is innocent prior to a trial? And 2, because everyone is legally innocent prior to a trial. So everyone gets to have a trial if they want to. no matter how strong the evidence is against them. It is an individual choice that each accused person gets to make. So, what if someone reliably confesses their criminal responsibility to their lawyer? This happens a lot. Lawyers serve dual purposes. The first part is to advise the client. As an advisor, a lawyer reviews the case and the evidence and gives the client options on how to proceed, the likelihood of success, and things the client can do to improve their chances. Our advice is better the more we know. Conversations between lawyers and their clients are privileged. That means they cannot be used against the client. So confessing to your lawyer has no legal weight, since nobody, besides the lawyer and their staff, will ever know the confession happened. So the best thing a client can do is answer the lawyer's questions honestly. If you lie to us, we may waste valuable time investigating a red herring or chasing down a witness that doesn't exist. Our advice to you won't be nearly as accurate if you lie to us. So what does a lawyer advise if a client confesses to the lawyer? Most often, the lawyer will advise to engage in plea negotiations, to try and resolve the case in the client's favor. Most of the time, that's what the client wants to do too. But remember what I said earlier. They have a right to a trial, and they can choose to exercise it if they want to. Sometimes they want to. There might be many reasons for it. I have had clients request trials because they didn't think a critical witness would show, or because they wanted to waste the government's time and money, or because they wanted to force a witness to come to court. I've advised clients to go to trial because the plea offer to resolve their case wasn't any better than the sentence we would get if we lose. There might be no reason at all. There doesn't have to be. The decision to go to trial is one that only the client gets to make, and they can make it for any reason, or none at all. So what can the lawyers say at such a trial in their client's defense? Lawyers have an ethical obligation called candor to the tribunal. This means you cannot knowingly lie to the judge, permit witnesses to lie to the judge, or knowingly misrepresent information to the judge. Lawyers also have an ethical obligation to keep their client's confidence, to not expose that client to harm resulting from that confidence, and to advocate for their client's stated position. There is some conflict there, but it is not as crazy as most non-lawyers think. Remember one of the first things I said. Story 17. My first time dealing with the legal system in court, received a driving under the influence of intoxicants, DUI, and reckless driving in Oregon, and I did not qualify for a public defender. My attorney was recommended to me from the State Bar website. I can most certainly say that I got a poor recommendation, and my attorney is not doing what should be expected from her. However, I'm not sure if it's just laziness and unprofessionalism, or if some of her behavior is beyond that. The two issues that I am most concerned about are the following. After I hired her, she requested an extension on my court date so she could have time to review the police report and other documentation. The week prior to my initial court date, she had her teenage daughter call me to update me on the situation. By teenage, I mean 16 at the oldest, and not someone who is an official member of her staff, such as a secretary. The child introduced herself as, quote, attorney's daughter, and then stumbled through the call with my attorney in the background, telling her what to say and correcting her several times. The next call I received from my attorney, she explained that she was driving, so she had her daughter make the call, and she even laughed about how awkward her daughter was on the call. My other issue is that my attorney continuously tells me about her other existing cases. She never mentions names, so maybe that makes it okay. She has detailed to me 3 different cases. Most recently, she had been out of town for a case, and when she returned, called me to notify me why I hadn't been able to reach her. She detailed the case, telling me what town/court it was, what charges were held against her client, that the client was from out of state, and how long they were able to extend the court date for. She ended the story with, I guess that just keeps them out of jail for a few more months, while laughing about it. As someone who has never dealt with lawyers before, I don't know what to think. She has portrayed a long list of unprofessional behavior that I am disappointed in, but these two instances leave an especially bad taste in my mouth, and I am not sure what to do about it. On our first meeting, we found out I used to work for her mother, and I'm worried by this behavior that she is telling her mother or other people about my legal issues when she should not be. Please tell me I'm being paranoid and looking too far into these issues, or maybe I'm not and you all have some advice? Thank you. Update. Was scheduled for court this morning at 9 a.m. Somewhere between the court opening at 8 a.m. and my hearing set for 9 a.m., my case was rescheduled. I was not notified by my attorney, who later told me she didn't find it necessary to let me know because she just assumed I wasn't going to show up, since she didn't receive my response from an email she sent me Friday that clearly stated, "Since I have not heard back from the court, we should be prepared to show up Monday." I do have proof that I responded to her Friday. I will be filing a complaint based on this, having her daughter contact me, and some other unprofessional behavior that I didn't feel necessary to include in the original post, but may help paint a picture of her lack of responsibility and professionalism. Much appreciated. This video does not promote illegal activity. Stories are shared for commentary and education. Story 18. Location: Kentucky. My wife filed for divorce last year. The case has had a lot of issues with her. Yesterday, I came home to find my desktop computer unlocked. I don't remember leaving it that way, but it's possible. I have not given her that passcode. A quick look at the browser history showed my wife as having gone to my Gmail, searched for emails involving my lawyer's name, and rapid-fire going through them, 1 to 2 minutes per email for 30-plus email threads. I'd assume this meant she was screenshotting them. I immediately notified my lawyer. There shouldn't be anything in them that would cause trouble. I took extra precautions and turned on a camera that had been off since she filed papers. It's in my office and only pointing at my desk. She's the one that insisted it be installed. Tonight, I caught her re-entering my office 3 times, monitoring the doorbell cam on her phone to see when I was coming home, and somehow unlocking my smartwatch I left on the desk. I never gave her that passcode, and I don't know how she got it. The app logs show she opened my text messages. I have changed the passcode since. She's convinced I'm hiding money and doing shady things. That's why she's going to these extremes. I live comfortable in that there is nothing I have to hide. My lawyer said I'm the most thorough and organized client she's had. Only thing it gave my wife is the level of communication and instruction I've provided my lawyer, and the things I've told friends and family about the case from the texts. My question is, how big of a deal is this, and how big of a deal should my lawyer make out of it? It sounds flagrant to me, and certainly something the court would look down on. Her first lawyer quit already. She just hired the second over the weekend. There is a lot of money and custody involved. I've had to file a lot of motions to get her to comply with reasonable actions surrounding assets and school for our child. Just trying to set expectations here. Update. Spoke with my lawyer. They said it would be most prudent to just tell her new lawyer that we know she did it and have record of her access, that future offenses will result in a protective order being filed, and that she needs to find a new residence immediately. This gives us leverage to push that, without needing to escalate it to a more expensive option, but we can go there with receipts if she tries to use any ill-gotten material. So take it seriously, but don't press in exchange for ground. Seems fair. This video does not promote illegal activity. Stories are shared for commentary and education. Story 19. The title kinda explains the bulk of the situation. My brother's girlfriend works for a law firm as a paralegal and deals with various documents of people, like house titles and whatnot. She tends to post on her Snapchat quite frequently bits and pieces of documents she's working with, making comments about someone's wealth and other personal information. Recently, she sent a snap to my sister, a picture of a document related to my great-grandma and her son, my uncle. My mom has seen the image and is wondering what the legal repercussions of this are, and is the image evidence enough for legal action? Edit. The bot said location is important. This is in North Carolina. This video does not promote illegal activity. Stories are shared for commentary and education.